I had the opportunity to view the video. Really disgusting, but it was not forced by force lah. So to me, it's not rape. It is categorized as statutory rape because the girl is willing and enjoying it also, and they were going rounds. It was an orgy with one girl, and basically there's no violence per se. It's still wrong. It's still against the law. So the law should take its place. This is unlike all the assailants yang bunuh orang apa semua tu lah. So yang rogol ni is actually statutory rape because dia bawah umur. Kalau dia punya umur tinggi, it's not even rape. It's berzina and kalwat whatever the laws are in place lah. Jadi kena clear sikit. Jadi orang punya netizen punya kemarahan tu mungkin tak kena tempat sikit lah. They did something wrong. Not sure whether they'll go to jail or not because dia tak mengenai siapa pun. Tapi dia langgar undang-undang lah. Dia langgar undang-undang because they had sex with somebody yang bawah umur. Jadi orang kena understand that. Kalau tak understand, then kita akan jump to conclusions. That's not right lah. I had the opportunity because benda tu spread. Polis pun dah ada video tu. And polis pun dah kata dah, it's not rape per se. It's not secara paksa. It was done and dia tolong tutup muka perempuan tu. Perempuan tu pun tutup muka dia malu. But she also consented to the video. She consented to the video and they were doing it and benda tu leak macam mana kan. And because that jadi case lah.
Statutory rape, Sharia overlaps and juvenile offenders in Malaysia by capture of this article. Legal position. Statutory rape, Sharia overlaps and juvenile offenders in Malaysia by AZLAN ADNAN, MA. Saturday, 18th of October 2025. Statutory rape under Malaysian law. Under Section 375G of the Penal Code, sexual intercourse with a girl below 16 years old is legally defined as rape, regardless of consent. This applies even if both parties are teenagers and the act was consensual. Punishment under Section 376, imprisonment of up to 20 years, and whipping of not fewer than 5 strokes. The key point: in law, a girl under 16 cannot give valid consent to intercourse. When the accused are themselves minors. The Child Act 2001 governs how offenders below 18 years old are treated. Juvenile proceedings focus on rehabilitation rather than retribution. While a minor can be charged with statutory rape, sentencing is handled differently. For offenders aged 15 to 17, they may be charged and tried in children's court. Sentences are governed by Section 91 of the Child Act 2001, which provides alternatives to imprisonment. The court may order bond of good behavior, probation supervision, detention in an approved school for a period not exceeding 3 years or until age 21, fines if deemed appropriate, counseling or community service, or discharge upon admonition if the circumstances warrant leniency. For serious offenses such as rape, courts may impose detention in Henry Gurney School until the offender reaches 21 years old. This is not considered imprisonment, but a custodial rehabilitation measure.
Dimension.
All parties being Malay Muslims brings state Sharia law into the background. The Kedah SYARIAH Criminal Offences Enactment and similar state laws defines. Section 25, Khalwat, close proximity. Any man or woman found together in suspicious circumstances may be fined up to Rm 3,000, imprisoned up to 2 years, or both. Section 23, Zina, unlawful intercourse. Any person engaging in intercourse outside lawful marriage may be fined up to Rm 5,000, imprisoned up to 3 years, or both. However, since rape and sexual offenses are federal crimes, criminal law takes precedence. Sharia action is secondary and rarely invoked when a civil prosecution is active, especially involving minors. Double jeopardy. Malaysia's federal constitution, Article 7.2, forbids double punishment for the same offense. But statutory rape and khalwat zina are legally distinct offenses. One protects public safety and minors, Penal Code. The other enforces religious morality, SYARIAH. Thus, concurrent proceedings would not amount to double jeopardy in law, though in practice, SYARIAH cases are often dropped or deferred once a criminal trial begins. How the law treats the 4 males, aged 15 to 17. All 4 are legally culpable under Section 375G. as the victim is under 16. Their cases will likely go to juvenile court, not adult court. The focus will be on rehabilitation, with possible outcomes including placement in a rehabilitation school, supervision or probation under a social welfare officer, counseling, or conditional release under good behavior bond. A 17-year-old may face stiffer treatment than a 15-year-old, but still under juvenile law. If any had recorded or shared videos, additional charges under the Sexual Offenses Against Children Act 2017 could apply, carrying heavier penalties. Conclusion. Federal criminal law governs statutory rape cases. Even for Muslims, SYARIAH law may shadow the moral aspect, but does not supersede federal jurisdiction. Juvenile offenders are held accountable, yet the justice system aims to reform rather than punish. The system draws a hard legal line. A girl below 16 cannot consent. Beyond that, it bends toward mercy for minors who cross that line without full understanding.